Thank you. Be seated. This is an action entitled State of Ohio Plaintiff versus George Wagner defendant, case number 2018 CR 154, dated December 22nd, 2020. And this is a pretrial hearing, and had also been scheduled as a motion hearing. We've had a little difficulty in getting the defendant transported here from jail, but he's here now. The defendant is present. He's appearing in civilian clothing without restraints visible outside of his clothing. He's represented by his attorneys today, Gregory Myers and William Mooney. The state of Ohio is represented by the Pike County Prosecuting Attorney, Rob Junk, Special Prosecutor Canepa is present, Special Prosecutor David Andrew Wilson is present. Ryan Scheider of Ohio BCI&I is also present. Our last pretrial was held on September 21. At that time, 7 different defense motions, I believe, have been addressed, at least mentioned there. The defense at that time requested that their motions number 47 and 48 not be heard that day, but that those be continued until October 29th. That was done, and then the October 29th hearing was subsequently continued to December 2nd, I believe, due to the illness of the defendant. And then that hearing was continued again until December 22 due to a conflict on the court schedule. So I'm not sure whether we intend to have 47 and 48 argued today. 47, defendant's motion 47 is an in limine motion to determine the admissibility of certain ballistics evidence. 48 is a in limine motion to determine the admissibility of shoe print evidence. So the defense intend to present those.
Your Honor, we would ask the court to once again delay adjudication of those motions in anticipation pursuant to discussions we had while awaiting the arrival of Mr. Wagner to the scheduling of a motion hearing date between now and the likely trial date, which we understand due to the absence of one of the court support staff. We won't pick those dates today, but I think everybody knows we anticipate by the end of the calendar year scheduling both a motion hearing date and a trial date.
All right. That is what we discussed doing, except that the state, our assignment commissioner for criminal cases is not here today, but will be returning in the next few days, and we will have that employee schedule I suppose an all-day motion hearing date for pretrial motions, and also schedule the trial in this case.
I'm sure. Yes, we are in agreement with that, and understand that we're unable to get those dates today because of the unfortunate absence of one of the court staff. Just for the record, and I know that we've made our opinion clear both in written motion and in chambers, but specifically as it pertains to motions 47 and 48, the state's position is that they're not entitled to a hearing on those matters. So that's, I just wanted to state that position for the record, but obviously we concur that we should set an evidentiary hearing date, and whatever hearings are right or entitled for a hearing should be heard that day.
All right, that's fine. So, and we anticipate by the end of this year that dates will be in place for the evidentiary hearing and for the trial. Defendant's motions 52 and 53 were granted at the last hearing. 52
was a request that the state furnish the defense with transcripts of audio recordings by the end of this year, 12/31. That, of course, date hasn't arrived yet, but how is that going? Are those complete or nearly complete?
Yes, Your Honor, those are nearly complete. We anticipate being able to meet that deadline as far as the recorded conversations go.
All right, and 53 was also granted, as I indicated. The state was to furnish the defense with forensic reports, underlying data, including bench notes, prepared for the state, provided to the state, or made known to the state, and those were to have been provided by October 29 was what we said on the 21st of September. However, we didn't have our hearing on October 29. So how are we doing on those, furnishing those reports?
Your Honor, again, we have provided that just today, on this date, bench notes from Matt White regarding 2 different August reports that we had previously provided them, August of 2020 reports. They were newer reports, so we just got the bench notes to them today for that. We provided 2 additional CDs to them as well. One specifically, and we did offer the explanation, is for the ATF agent who had done an analysis on the homemade silencer. That particular scientist who did the initial examination back in November of 18 is likely not going to be available for testimony. And so we are in the process of resubmitting that item to a new analyst with ATF out of the same office. So we provided that name today, but we will provide the report once that is completed and we receive it.
Is that satisfactory to you?
Yes, Your Honor. And about Mr. Rhoden now, or he says his name?
Right now, yeah. Yes, we will also get that report to you.
Right. We also received, if I may, a CV of a person by the name of Aaron Rhoden, who is apparently, according to the CV, holds himself out as a ballistics expert, among other things. And we anticipate that there will be a report also from Mr. Rhoden forthcoming. I don't know, Ms. Kenneth, if you have a sense of the time on that?
I hope soon. I mean, obviously, I will provide it to you as soon as I receive it.
We understand, as the record would reflect, in part through our motion 47, ballistic work was done by an employee with BCI&I, Matthew White. And apparently, Mr. Rhoden stands ready to review some of that work and render an independent or render an opinion about it.
Yes.
So that's our understanding, and we'll wait for the report.
You will want those, I'm sure, in advance of a motion hearing date.
Yes.
That we're going to schedule. How far in advance of that hearing would it be fair to have those provided?
Well, I would say, not to correct the court, but I think I'm speaking in the singular here, not in the plural, because the ATF agent is a person who is going to evaluate what the state believes to be, or the first expert believed to be, a homemade firearm suppressor, sometimes referred to as a silencer. So we did not attack or question that in any of our motions. Motion 47, though, does talk about ballistics, and that would implicate, we anticipate, Mr. Rhoden, so sooner the better.
Yes, and Your Honor, just for the record, I have already communicated to opposing counsel, and if they don't call, and I'm reiterating currently, to say that he has already provided an oral report to us, and simply to say that he, agrees with the conclusions that Mr. White reached. But I have requested that he reduce that to writing, so that I can provide that to counsel.
Do you have any kind of deadline or any kind of timeline that you could assure us?
I can say the end of January, if that's okay. It's a month from now, within the next 30 days.
I mean, he's already looked at it, if he can, hopefully no later than that. Right, so should.
Yes.
So,
If I control his schedule.
so no later than January 22. All right. With respect to defense motions 49 and 50, it was indicated that the defense was to supplement or file supplemental memoranda in support of motions 49 and 50. 49 was an in limine motion requesting a pretrial evidentiary hearing to determine the admissibility of written communications that the state intended to use in its case in chief. And 50 was an in limine motion requesting pretrial evidentiary hearing to determine the admissibility of any non-testifying co-defendant statements that the state intended to use. I think the purpose for the supplemental memoranda was, I think the state felt that the specific written communications and the specific non-testifying co-defendant statements that were objected to, that those should be specified. Where are we with that? That was, that again, I think was, it was indicated by the defense that might not be possible to file any additional supplemental memoranda by the 29th of October because you weren't sure, I think, at that point that you had everything that you needed, and you certainly had to look through what you did have, but where are we with defense motions 49 and 50?
The bottom line today would be to request the court's indulgence and allow those motions also to be set for hearing on the date established for 47 and 48. It's also, as it turns out, our motion 50 regards the questionable admissibility of non-testifying co-defendants. Further facts relevant to that motion are very likely to be forthcoming in transcripts the state has indicated they will provide for us with. I think that's what we mentioned earlier about the end of this calendar year. So those transcripts, I think, will wind up impacting at least that motion.
So those will be heard then on the day that we set aside for motion hearings prior to trial.
Roger, to that end, could we set some sort of deadline, whether it's 30 days before or, however many days before the actual hearing? I know we don't have a hearing date, but if the court could just indicate that maybe, 30 days prior to that hearing, the defense provide the state with any supplemental motions that they would have, or supplements to the motions, I should say.
That's fair. We'll anticipate that deadline being incorporated by default with respect to the date for the motion hearing.
Yeah, the date that was set for the motion hearing, 30 days prior to that, and the defense will have filed all pretrial motions that are to be heard on that day and any supplements to previously filed motions that they intend to have filed, so that the state will have adequate notice before that hearing date. Motion number 51 dealt with whether the court should order removal of Special Prosecutor Wilson due to his relationship with the governor's office. And we had a stipulation of facts as set forth in the memorandum of the defense motion. And now I think we have a few additional facts that the state was going to put on the record. We discussed a little bit in chambers. The state's going to put those on the record, and then we'll see whether the defense can stipulate those. We wish to put those on the record.
Yes, Your Honor. Two additional facts that both parties are willing to stipulate, I believe, and obviously correct me if I'm misstating that. The first fact would be that regarding Andy Wilson, he was brought onto this case back in the spring of 2018 in a consulting role where he was provided access to the file, had to sign an affidavit of non-disclosure such that he would keep the information confidential, but in that regard was given access and did consult with us on various issues regarding the case. So his involvement actually predates when the court officially appointed him, which was June 24th of this year. And that was, oh yes, and sorry, that was in his role as the elected Clark County prosecutor at the time. So not working for Mr. DeWine at the Attorney General's office, or obviously not at the Governor's office in 2018. I believe that is it as far as that particular stipulation goes.
We so stipulated and had a chance to run this by Mr. Wagner, so we're all in agreement that we stipulate to those facts.
I thought there was something also, there was something else.
Yes, Your Honor. So the second stipulation that we would put forth is that Mr. Wilson is serves in a policy-making role for Governor DeWine. He has since placed a wall up between him and any policy issues regarding the State Public Defender's Office. That has been completely relinquished, and the individual that now is handling those issues, Mr. Wilson does not maintain any supervisory capacity over him, and so he is completely out of that equation.
As discussed in chambers, we would stipulate to that. I must admit, just here now in court, I'm wondering if there's any additional facts descriptive of whether Mr. Wilson, notwithstanding this wall between folks in the governor's office who do the things we described in our motion relative to the Ohio Public Defender's Office, right, without repeating all of that. I would wonder, though, whether Mr. Wilson retains a responsibility or at least an expectation that he personally would keep the governor updated on all of these proceedings. Because, you know, ultimately the governor will have that final authority as we described in our original motion.
Are you talking about these proceedings?
Yeah, about this prosecution, about the
proceedings?
prosecution of George Wagner, whether the governor is maintaining a personal interest in it now in his role as governor.
Your Honor, the governor has not intervened in my representation of the case in any way, shape, or form. And there is no reporting duty for me with respect to my obligation in this case. The only communication I've had with the governor really about the case is potential trial dates, so that we can plan for how that affects my role as in the policy side of the governor's office. So there is no reporting responsibility requirement with respect to how that is.
And we certainly accept that representation of fact and so stipulate to all these facts that now are ready for the court's review to adjudicate our motion 51.
And the court will issue a ruling on that motion number 51, defense then. There was an oral motion made at the hearing on September 21 for a transcript to be provided at the hearing of August 31, which was the bond hearing involving another defendant. And the court did grant that. The court's understanding that the defense has received a copy of that transcript.
That is correct. Thank you, Judge.
And the state has as well.
Yes, yes. Go ahead.
The state had filed a motion on September 4 for an extension of time to specify other acts, evidence pursuant to evidence rule 404B. That had been extended to October 29, 2020. That the court had granted that motion at the September 21st hearing and extended the time to October 29. It's the court's understanding that from discussions in chambers with counsel for both sides that that by agreement will be further extended to the end of the business, at the end of the day, tomorrow, December 23rd. Is that correct?
Yes, Your Honor.
Understood, yes.
The final thing we wish to discuss, in view of the fact that we are in anticipating a trial date being set and a motion hearing being set. Was a speedy trial issue, you wish to address that?
Your Honor, we have been given a written waiver of speedy trial form, the same one that we have filed before. Mr. Myers and I have gone over this with Mr. Wagner. We've discussed both his statutory as well as his constitutional rights to speedy trial. We've discussed with him the fact that he had previously extended his waiver to January 30th of next year. And he has executed a written waiver of speedy trial to be effective from January 31 of 2021 through October 1 of 2021. And Mr. Myers and I have witnessed Mr. Wagner's signature. May I approach, Your Honor?
Mr. Wagner, do you feel that you've had an adequate opportunity to discuss your right of speedy trial with your attorneys here?
Yes, sir.
And you feel that you understand your right of speedy trial?
Yes, Your Honor.
And of course, you know, if the court did not afford you a speedy trial, then the charges would have to be dismissed and could not later be brought. You also understand that, correct?
Yes, sir.
And that if you waive your right of speedy trial, then the court can set a trial beyond any speedy trial times that would otherwise apply. You also understand that?
Yes.
And do you wish to waive your right of speedy trial as stated on this document through October 1, 2021?
I did, Your Honor.
And did you sign this document?
I did, Your Honor.
And did you understand?
Yes.
The court will approve the defendant's waiver of the right to speedy trial through October 1, 2021. Do you feel that you're, Mr. Wagner, that you're having an adequate opportunity to work with your attorneys and to have access and contact with them?
Yes, Your Honor.
Are you satisfied with the services that your attorneys are providing?
Very.
Do you have any complaints at all about the process?
I'm sorry.
Do you have any complaints at all about the process and about how you're being treated and dealt with in the case?
No, Your Honor.
Is there anything further from the state today?
Yes, Your Honor, if you don't mind. I was just, I didn't realize we weren't going to argue motion 51, which is fine if the court's, just happy to rely on our filed briefs and such. But I did want to place on the record something that was stated in chambers in September that I was going to place on the record today, which was simply, and perhaps I should have done this by way of stipulation, simply that both Mr. Myers and Mr. Mooney assured the court that they would never compromise their representation of Mr. Wagner, despite any overarching issues that they were raising in motion 51. So I just wanted, obviously they sent it to the court, so perhaps the court, has that, but I felt it important that it should be on the record.
I'm sorry, I can't.
When we were in chambers September 21 of this year, Mr. Myers and Mr. Mooney both indicated that they personally would never compromise their representation of Mr. Wagner. So I just wanted that to be made part of the record, and I'm sure they would reiterate that. They have an ethical obligation, obviously, to represent him.
Well, fundamentally, we stand on the writings in relevant to motion 51 that recognized, among other things, the unique variables put in play by the institutional nexus between the governor's office and the office of the Ohio Public Defender. So for those reasons, for instance, we didn't feel it was proper to ask Mr. Wagner himself to execute a waiver, because this is not a normal waivable sort of issue. I say that now in response to Ms. Canetta's most recent comments, because on the one hand, Mr. Mooney and I are obviously not spring chickens anymore. We've been doing this for quite a while, and we've always intended to do our best for everyone we represent, including Mr. Wagner. But not being able to control, we're not in private practice. We are beholden to a chain of command within our office, which in turn is institutionally beholden to funding, financial oversight, ultimately by the governor's office. So that's a long-winded way of saying that, on the one hand, we want to do and will do as best we can, but we can't peer into a crystal ball and pretend to have power of a throne we don't hold, as it relates to the issues raised in that motion. And I think that's all that can be said. I mean, to put it another way, not to overdo it, but for us, Mr. Mooney or myself, to make a declaration, our full intent is to represent to the best of our ability. Well, that's it, to the best of our ability in circumstances, some of which are unforeseeable. So a mere statement, the one I just made, the one Ms. Angenette has summarized, does not, in our measure, negate the compelling reasons for our motion 51.
Is there anything further from the state?
No, that's all I have.
Is there anything further that the state wishes to put on this record today?
No, Your Honor, not at this time.
Anything further from the defense?
No, Your Honor.
Thank you very much.
Thank you, Your Honor. Merry Christmas. Yeah, you too.